Call the fourth case on this morning's docket, case number 115629, State of Kansas v. James Lee Jamerson.
Good morning. May it please the court, the state appears by Assistant Solicitor General Jody Litfin. And Your Honor, I would request 2 minutes for rebuttal, please.
2 minutes is granted.
Thank you. Just a brief factual summary of how this case got before the court today on the state's petition for review. Back in 2001, the defendant was charged with 1 count of first-degree premeditated murder, or alternatively felony murder, 1 count of aggravated robbery, and 1 count of conspiracy to commit aggravated robbery. Based on the factual scenario that the defendant and some co-defendants agreed and devised a plan to rob and murder the victim here. They carried out that plan, drove him to a secluded location, got him out of the car by gunpoint. The defendant shot the victim 1 time, tried to shoot him again, the gun jammed, and the co-defendants repeatedly shot the victim, who survived for a short period of time at the hospital but was later died. The case proceeded to trial, and a couple of days into trial, the defendant indicated that he wanted to initiate plea negotiations. The state and the defendant ended up with a plea agreement that the district court accepted, which was to plead no contest to 1 count of second-degree murder, the conspiracy to commit aggravated robbery, and the aggravated robbery. The sentencing recommendation was for a sentence of 288 months, or 24 years, and it's not really clear that anything was taken into consideration for criminal history-wise for that term, but that both parties were satisfied that that was an appropriate sentence to agree on. And I didn't mention that the state had filed notice of its intent to seek a hard 50 sentence, so that was on the table as well, and it was taken off with the plea agreement. The district court accepted that plea agreement, found that the defendant knowingly, voluntarily, and freely entered into it, and they proceeded to sentencing. Prior to sentencing, the defendant moved to withdraw his plea. That was denied, and the sentencing court found that this was an appropriate sentence, and in order to get to the 24 years or 288 months, the district court did the presumptive sentence for the severity level 1 crime of 253 months, and then departed on the other 2 non-brace crimes to 35 months each, which it thought it was doing a downward departure for both, ran the aggravated robbery sentence consecutive, and the conspiracy to commit aggravated robbery concurrent, getting to 288 months, and there was no objection to the criminal history at that time, which was scored as a D. Over 10 years later, I think 12 years later, there was a motion to correct an illegal sentence filed by the defendant in district court, and he argued there that his criminal history score was incorrect. It should have been H and not D. The state agreed with this. A hearing was held in 2015 or 2016. The court granted the motion to correct an illegal sentence and ordered resentencing. At that resentencing, the judge...
But why is there resentencing? I understand Grutter and those Morningstar and all those cases involved a remand from this court after a vacation of 1 or more counts. But this is a motion to correct illegal sentence. Why doesn't the district court simply correct the illegal sentence rather than resentence? You understand what I'm asking you?
Yes, and I think that's the rub with what and the district court believed was to be the illegal sentence, which was all of the counts. And what the defendant was arguing was the illegal sentence was, it's just the base count, because that's the only thing that really changes with his criminal history changing from D to H.
So you're saying you're arguing if one portion of a sentence is illegal, that portion can't be corrected, you resentence for the whole thing.
Yes. I'm arguing that when a motion to correct illegal sentences is brought back before the district court, they have the discretion to find the entire sentence illegal. Yes.
What is it that makes the entire sentence illegal here? Are you saying that the faulty criminal history score taints the entire sentence.
Yes. I'm saying that it gives the judge then the jurisdiction to go back and resentence when there is no mandate or order from an appellate court limiting the district court's discretion in only vacating one sentence. And I don't think in any of those cases,
But how do you get that from 22-3504-1? It says you can correct an illegal sentence at any time. It doesn't say you can resentence at any time when you have a flaw.
I think I'm just reading in the remedy of when there's an illegal sentence, you get resentenced.
Well, let's talk about something that applies here. That you would agree that if someone's sentenced where one count is ordered consecutive and one count is ordered concurrently, that's part of the sentence.
Yes.
And that if you change from concurrent to consecutive, that modifies the sentence.
Yes.
And we have, so when the district judge changed from concurrent to consecutive, that wasn't illegal in the first place. That was a modification of a part of the sentence, which 2147-21I, well, whatever it is now, precludes. The district court doesn't have authority to modify. You would agree when it went back to the district court couldn't modify, it could only correct an illegal sentence.
Yes, and I think I'll answer that in with a couple of points if I can remember them
Okay.
all. One, if we're parsing this out to counts here, any count that the district court finds to be illegal, which would be the base count here because that was on the incorrect criminal history, and it found the conspiracy count to actually be an improper upward departure. So let's say that's illegal. We're arguing secondarily that the district court has the ability then, those two sentences were illegal. You can reconsider those completely. So you can go consec or concurrent on those two. So I don't think that's an improper modification when you find the sentence to be illegal. Now, if you're dealing with the middle count, which the defendant's arguing that was never illegal, and if you're saying we have to take these counts separately and go back to the 35 months, you can't change the consecutive or concurrent. That would be
Here it was all run consecutive
right.
on resentencing, but one of the 35 was concurrent. So that has changed.
Yes, and I think you can do that because that was one of the counts that the district court found to be illegal. And it changed it to the 34 months, which is now correct.
Well, let me ask you this then. Under your theory, if someone is sentenced to the low number in a grid box, and it turns out it's the wrong criminal history, when it's sent back, the district judge can pick any number in the grid box
Yes.
and run it consecutive, and so that they can just start over again.
If it's been vacated, yes, that's my understanding of when you vacate
Well,
a
it's
sentence.
not vacated. No one's vacated this. We have a motion to correct an illegal sentence, and the defendant's saying, Judge, this is illegal, correct it.
So how do you resentence without vacating that sentence? I guess would be my question is, you don't call it vacating the sentence, you just call it correcting the sentence, and that's it. I don't know about that legal distinction. I don't know if there's a difference between those two. I guess practically speaking, I'm thinking of when a district court is, and I haven't dealt with any of these through Dickey because I'm sure they're there, they're saying my criminal history is incorrect. I need to be resentenced under my correct criminal history. What do you do with that incorrect sentence? You don't vacate it, you just correct it. Which maybe that's a distinction that this court can make, but I'm saying that it should be vacated if it's an incorrect sentence and you have to go back and redo it.
But you can't modify it. You can't modify a sentence. You agree with that?
Yes.
You can't modify a sentence.
A legal sentence.
Okay.
Yeah, sure.
You have individual sentences for the counts, but you also have an overall sentence.
Yes.
You made that point in your brief. You want to talk about that?
Sure. I think that's another thing that I was rewatching some of the oral arguments that before in Woodbury and Snow, it was all one sentence. We didn't parse out counts. You couldn't do that. Now we've changed to talk about each sentence is different for a count. And I think that there's a specific situation here which is interesting in that this was a plea agreement where we didn't really care about the counts. That wasn't important. The number was important. So the total sentence was what really the agreement was and what both sides considered to be fair. So I think that's something that this court should consider in specifically.
How do we consider, it wasn't that the modification, the illegal, whatever you want to call it, but what the district judge tried to do was make it consistent with the original plea agreement. And however you get there is how you get there, but that was, and how do we take that into account here? Should that matter or not matter?
Well, our position is that it should matter, and I think all I've got to go on is from a public policy standpoint, a fairness standpoint, that the state's not trying to hose anybody here. The district court's not trying to get around any sentencing loopholes. They're trying to get it back to where both parties agreed that this
Right.
was fair.
And that the court apparently agreed and wanted to put into effect the plea agreement.
Yes, and just because it was a little hinky here and they did some departures, not knowing in the future what could happen in criminal history over a decade later, that wasn't important to them. It was just the number, and that's what they found to be fair. And it cut 25 years at least off of his sentence. He got him back on the grid to have good time too, which could cut off another, I want to say 4.5 years maybe. So I mean, this wasn't something that was a bad plea deal to do the 24 years. So yeah, I think the district court should have the discretion, and I don't think the sentencing guidelines take that away. But can I point you to any authority, statutory authority that has that? No.
That's,
Yeah.
How does the mistaken criminal history taint the non-base sentences? And do you have any authority that says that those non-base sentences were illegal?
Our position would be that when the district court granted the motion to correct an illegal sentence, it vacated the total sentence.
But in order to, let's say we agree with you that as a matter of legal mechanisms, that's what happens. Mm-hmm. If a sentence is illegal, it's vacated either in substance or in name. And then there's a new sentence. Let's just grant that for the purpose of my question.
Okay.
Don't you still have to have the underlying finding that those non-base sentences were illegal? And that's where I'm stuck. How do we get to a lawful finding that the non-base sentences were illegal?
I guess I would go back to the common law where you're treating the sentence as one and not the scenario which was in this court's case law in Gooder, Morningstar, even Warren.
Well, let's take a hypothetical, and we have real cases where this happens, where let's say you've got a tail of a sentence, say a period of post-release supervision. That's wrong. There's going to be an illegality found, and it's going to need to be corrected. Your position would be that the whole entire sentence is now open for relitigation. I mean, if we were in a circumstance where the defendant had come in and argued for a lesser sentence and prevailed, I would imagine the state would be here making a very different argument.
Well, that is what happened here. We agreed that his criminal history was wrong, and we agreed to give him a lower sentence here. So I understand what you're saying, though, because the state does file motions to correct an illegal sentence when we realize that there's been 36 months of post-release ban. It should be lifetime. And I don't know the arguments that are made below, though, and I don't know if the defendant tries to argue that it is opened up. And
well, you're arguing that it's all opened up.
Sure. So I don't know if it swings both ways. I mean, it would have to, I guess. And I guess that's the risk that we take in considering a sentence as a whole rather than these separate parts.
So you're here to argue we should overrule Gooder?
I don't know that you have to specifically overrule Gooder in the facts of this case. I think that they can live harmoniously if you want to say that this is just not controlled by Gooder, because Gooder really focuses on the mandate from a higher court. Morningstar does too. Warren does also. We don't have that here. So really, this is a unique scenario where the motion to correct an illegal sentence arises at the district court. The district court granted it, vacated it, needed to correct the sentence. I'm not sure how all that's going to work out, and then did so. So what authority does the district court here have to resentence without a mandate from a higher court specifically vacating a certain sentence. So I think they can live together.
And would that include the authority to increase the sentence that was originally imposed?
I think it would include the authority to open up the entire sentence, not treat them as counts.
So if you are a defendant and you think you've been sentenced illegally, beware, because you might get what you ask for and you'll get a higher punishment.
I think that, well, I don't know if it would ever be higher.
That's what I'm asking.
I don't think it can be.
I don't know if it would be higher, but I think you open it back up for reconsideration of the other counts. But also, I don't know if that would prohibit the defendant from then filing for a departure. If we open it up, do all of the sentencing, can they file for a downward departure?
So under your sauce for the goose is sauce for the gander, then all of the times in which we have a later motion, when someone's about ready to get off post-release and the state goes, oh, well, it should have been lifetime, that what we need to do then is remand it to the district court for complete resentencing.
I think this court can order the district court to very specifically whatever the correct
I don't know
post-release is.
what that will do, because we've already said that you don't get post-release credit for if you've served too long, but you get my point. Anytime that you find post-release or something like that is illegal, then we have been wrong in changing that. We needed to send it back to the district court, because the district court has discretion to completely consider the sentence anew.
I don't know if this court, I don't think that they were incorrect in doing that. I think that this court can specifically, in their mandate, order the district court to very specifically fix something. I think
But
the
under
problem
your theory
comes-
of the case, the district court has to have a complete do-over. That's
that's
what
what-
you're arguing.
I think what I'm arguing is, where does it come from? Did the district court find that the sentence was
Well,
illegal?
This court doesn't pronounce a sentence. I mean, your argument, as I understand it, is a sentence is unitary, and one small part of illegality taints the entire unitary sentence, and so there has to be a new sentence, and that has to be done in the district court, doesn't it?
Right, but I believe in this court's cases where they've said the sentence is vacated. They've never found the sentence to be illegal, I don't think. I think in Morningstar, wasn't it, they just vacated the sentence because it was an incorrect severity level. In Warren, it was vacated because it was found unconstitutional. So I don't know that they've ever found that it was illegal, but they've said the sentence is wrong and needs to be vacated. So I guess my issue is when it's found illegal.
The aspect of the sentence that is illegal needs to be corrected.
Right.
Which is different from saying the entire sentence is illegal and needs to be redone.
And I understand, yes, and I guess a district court would have to make that specific finding that here the base count was the only count that was illegal, that's the only one that I'm going to fix. But then it gets back to my public policy argument, I think, of when they're so intertwined, as in this case, I think there should be an exception to that. When there's a plea agreement.
And so that if we apply that public policy, we can apply that across the board too? So that when you move for a correction of a lifetime post-release, we can say, well, that wasn't contemplated because they had an agreement, so we need to send it back and grant them probation on or something, change the sentence to make up for the fact that prosecutor and defense counsel misunderstood what the sentence should be. So, I mean, you're okay with that?
No, I understand your point, and maybe I didn't think about the post-release aspect of it, but is that under 4720, or is that under another statute? Would be my next question.
Regardless of public policy or whatever that argument is, 4720B says the sentencing judge may consider the need to impose an overall sentence that is proportionate to the harm and culpability, and shall state on the record if the sentence is to be served concurrently or consecutively. And the question is, in a resentencing scenario, in this case, correction of an illegal sentence, whether or not the judge's duties with regard to 4720 are muted or not. That's the question, right? I mean, forget public policy, but, you know, the legislature's spoken in 4720, and the issue before us is how much of that does the judge get to do when he resentences in a motion to correct a legal sentence?
Well, even more fundamental, the motion was filed under 223504-1, which is not part of the Kansas Sentencing Guidelines Act.
That's correct.
And they're asking for a correction. And so the fundamental question is, what you're wanting to do is, do you send it back to the Kansas Sentencing Guidelines Act for resentencing according to those terms? Or are you, because if you go back there, you're faced with the fact that you can't modify, right? And so what does it mean to correct any time under 223504-1? Does it mean send it back into the Guidelines Act?
Right. I mean, I think that's the question is, when you grant a motion to correct an illegal sentence, one, is it just the count that's illegal? And two, does that just mean a resentencing? Does that equal a vacating of that sentence on that one count, or whatever it may be? And then two, do you get to jump to the sentencing guidelines? Because I think once it's opened back up, which is what I think the district court was trying to do here, you can. And you get to redo an entire sentence, and I think this court has said vacate means do it over and do it over right. I mean, the point is to try to get this person a correct sentence. I think what the district court was trying to do here was to really comply with the spirit of the plea agreement that was back in 2001, 2002, as well as correct his sentence. So I see I'm out of time.
Do we have any further questions? Thank you, counsel.
Thank you.
May it please the court, Joseph Desch on behalf of the I represent James Jamerson, and if it helps any, I represented him all the way through this process. I'm going to be brief. I'll always try to be brief. This goes back to the old maxim: if it ain't broke, don't fix it. When an illegal sentence is vacated or corrected, however you want to put it, whether it's by the district court or by the Supreme Court, the end result is the same. You correct that sentence which is illegal, or the portion thereof which is illegal, which comes out of the Boswell and the Johnson case. They're the first ones coming up in my brief. It's a distinction without a difference. If it's the district court, it's still the same set of legal guidelines that we have. The sentencing is a creature of statute. The sentencing guidelines give the court its ability to sentence, and at this point, they do not give the district court authority to modify sentences which are not illegal. And we go back to the state has argued in its brief, and we've kind of changed the argument today that 214720 gives B5 gives the authority of the court to resentence the entire thing based on an overturned conviction, but that's not the case here. It's a sentence that is being, as you put it, Justice Johnson, corrected. As far as this being one unitary sentence or being a conglomeration of different sentences, it's pretty obvious that the 4720 provides for the way to assemble sentences with one base sentence and other subjugated sentences, or however you want to put that, the inferior sentences. And those inferior sentences are sentenced without a criminal history. The base sentence is sentenced with criminal history, and how do you mix them up? That's kind of what we end up with. The statutory language doesn't change any premise that it's only an illegal sentence that can be changed, but a legal one can't. An illegal sentence can be changed, corrected. A legal sentence may not, and that goes back to, there's a Pennington case that I cited in my brief too that says you cannot correct a sentence that's legal.
Fundamentally, that's what we're talking about, is the sentence the components, or is it the 288 months? That's what Judge Mott asked, is that's part of the consideration for the sentencing judge to arrive at a total. And is that, so was Judge Wilson correcting the 288 months, or was she correcting each of the components?
Well, Justice Johnson, I apologize. When we did this, the petition and the amended petition or the amended motion actually specifically stated, we're only asking you to change the base sentence because it's the only one that is illegal based on State v. Neal, that a sentence based on an improper criminal history is an illegal sentence.
But Judge Wilson was permitted to recognize that the 35 months was an upward departure and correct it, wasn't she?
She did do that sua sponte, yes.
I mean, but that was, you're not complaining about that, are you?
No, Your
Okay.
Honor, I'm not. What happened there was we went all the way to a second hearing on the motion, and the second hearing, the judge, well, it was kind of revealed that there was a mistake in the original journal entry and the original PSI that showed that second count was actually sentenced. Well, it was actually sentenced as an aggravated robbery rather than conspiracy to commit aggravated robbery. And so that departure, which was initially a downward departure by Judge Andrews, was really an upward departure by 1 month. So that being said, she sure had authority to change that one. It was an illegal sentence. So, and she did follow that rule. The problem that we end up with is that third count, or actually count 4, was amended up to a 59-month sentence from a 35 months departure, and then that was run consecutive. And that's really the only thing we're really arguing about today. The Court of Appeals got it right. Gooter is the law of this state. It's been upheld in Warren and Tafoya, although Tafoya was kind of an outlier. It didn't really, it was kind of a weird mix of a DUI case and criminal law. But I'll just say that Tafoya didn't really, the holdings of Tafoya were confusing the actual facts. But at any rate, Warren is much more akin to this, and you have the upholding of Gooter, and our position is simply, if there is jurisdiction to resentence, it's only based on an illegal sentence. You can't resentence cases that are not illegal.
And so given that,
Yes.
You've got an illegal sentence, and let's say we're going to limit it to the sentence on one count, to the base count. What's the scope of the correction that's available to the district court judge?
Well,
are you trying to cabin the scope of the correction as well? In other words, I'll go back to a question my colleague asked earlier. If the initial illegal sentence went with the low number in the box, can the judge on the correction move to the high number in the box?
Well, that's exactly what she did here. That's exactly what Judge Wilson did here. On the first count, she bumped it up to the top, the aggravated number, which wasn't used in the beginning. But we're not arguing either way on that. I think if it's illegal, she can resentence it. Even going up on that count from the standard number in the box to the aggregate, I think she can do that. I don't think she did. The one thing I did want to bring up that's it's kind of, we didn't.
If she can
Yes.
do that, why can't she go from concurrent to consecutive?
Yeah, that was my follow-up question.
Right. Well, that's where I thought you were headed.
Well, she's not changing the character of the sentence. That's the character of the sentence, too, I'd say. The character of the original sentence was, this is the base sentence, and this is how long it is. The concurrency comes, or the consecutiveness, I guess, would come in the lower counts, because truly, the base count is the base count is the base count. Now, when we resentence on the secondary one, she could have gone consecutive or concurrent if she'd chosen, but in the prior decision, in Judge Andrews' decision, he went consecutive. And I was going to make this point, though, that if there's anything wrong with the Court of Appeals decision, it's 1 month too long, because they chose the wrong count to run consecutive in accordance with the judge's orders. The count 3, which was the conspiracy, which got dropped to 34 months, was not used as the consecutive sentence to the base count. So it should have been 210 months. We did not file a opposing petition for review on that point, at my client's request, I tried to explain to him that, hey, we did a great job, we got what we really wanted, and his time's up anyway, he's ready to get out. At any rate, I'm going to address a couple of the state's arguments.
Counsel, before you do that.
I'm sorry.
His original sentence 16 years ago was 35 months for conspiracy, correct?
Well, yes.
And that was concurrent with the second-degree murder sentence.
Actually, I'm wrong. Let me back up. His original sentence was 35 months for aggravated robbery, but that was corrected later on.
But he also got 35 months for conspiracy.
That's correct.
That was
No, actually, let me try again. The original journal entry says, or at least the judge's pronouncement was aggravated robbery on both counts. And I'm not sure, I have the original journal entry from 2002, but I believe that was a mistake that was uncovered at that second resentencing hearing with Judge Wilson in 2015. It had always been put in the PSI incorrectly.
So he's never been convicted of conspiracy to commit aggravated robbery?
He has been. He has been. But the journal entry was reflected incorrectly in the in the 2002 journal entry, or the PSI.
The original showed 2 ag robberies, right?
Exactly, that's what I was trying to get at.
Yeah.
Instead
rather than
of
one
one
ag robbery
conspiracy.
and 1 conspiracy to commit ag robbery.
Right, and so the PSI recommendation was the guideline sentences, and I don't recall exactly what it was, but 100 and somewhere hovering around 100, and then the third one was around 59, 55. The point being, the count that was ordered consecutive in the first place was the 35 that was the conspiracy. Count 3 should have been the conspiracy, and that was what was reduced to 34. That's my whole point on that. If I might address a few of the state's arguments, and I will open up to whatever else you want to ask. Criminal courts are not courts of equity. They're courts of law. They have rules to follow, and those rules are the statutes of the state of Kansas. And when they're not ambiguous, they have to follow that, and that's where their jurisdiction lies, and that's how we have the interplay of 223504 correct the illegal sentence, or the portion thereof that is illegal. So,
But it just says illegal sentence, right?
well, it says illegal sentence, that's correct. But the authority that gives them authority to mix them together is this 4720, which says base sentence, and the other sentence, and the next sentence, and the next sentence.
But if you're going to 4720, it also says what I said earlier. The sentencing judge may consider the need to impose an overall sentence that is proportionate to the harm and culpability, and shall state on the record if the sentence is to be served concurrently or consecutively. It's the judge's opportunity to look at set the penalty proportionate to the harm and culpability, and you want to, if I use a word from the other end here, cabin that.
No, not necessarily, Judge
No,
Martin.
okay.
I think I want to make it clear that the portion of the sentence that is illegal should be corrected. Those portions of the sentence that are not illegal should not be corrected. Just like the example, and I don't remember who gave it, that these post-release cases, I've encountered one of those where the guy comes back 15 years later after his sentence is over, his prison sentence is over, he's about off post-release, but no, you're a lifetime post-releaser and we're going to correct this illegal sentence right before you're off post-release. Well, that's happened before in one of my cases, and certainly that is a jolt to the defendant. But in this case, only that portion could be fixed. We didn't go back and say, as the tail end, I believe Justice Segal said, we're not correcting the entire thing. That's part of the sentence that was illegal. That's the portion. And that's where I go back to Boswell and Johnson, which are inferior court cases. However, they are certainly instructive on that portion of the case that should be fixed.
Why doesn't the erroneous criminal history render the non-base sentences illegal?
Because they're based on criminal history. They have no criminal history based on it by statute. There
In
is
other
no
words,
criminal history. I'm sorry.
The argument is that the error doesn't impact those sentences at all statutorily. So those non-base sentences were proper under the statutory scheme.
Well, initially it was argued that way, but I mean, theoretically speaking, yes. Those non-base sentences are not affected because criminal history is not figured into non-base sentences. They're all I's.
Well, and you have the tension of, colleagues talked about 4720, but 4721 says that you can't modify.
Exactly.
So you have the tension between correcting and modifying. So I guess the question is, if the original sentence was 288, but it's based on some 288 months, it's based on some illegality, can the district court finagle the other counts, boxcar them, and get back to 288 months so the total overall sentence isn't modified, but the pieces and parts are, and that's a correction?
Well,
or is that a modification?
With all due respect to Judge Wilson in this case, that's exactly what she did. She got the highest possible sentence she could put in there at 279
Well, the
months.
question is, why is that a modification and not a correction?
Well, it is a modification. It's not correcting the illegal part of the sentence. It's correcting, well, it's
But
modifying the
it
entire
corrected
sentence.
the overall number of months, if you look at the overall sentence.
Well, I guess that's a kind of one of those questions we have to leave up. I don't know. I don't know the answer to that, Justice. Sorry. Like I said, with that, I'll just say this. The states asked for, in their briefing, asked for carving out an exception. I think the Kansas Sentencing Guidelines Act is already a nightmarish hodgepodge of exceptions and contradictions, and we don't need to change any more rules. We need to go by what they have in there. And that's my personal opinion. But I mean, we have so many exceptions to the original rule. The original idea of Kansas Sentencing Guidelines was to make the sentences more uniform for people in similar situated circumstance. So we don't have black men getting longer sentences than white men. And that was the original idea of the sentencing guidelines, was to fix the problems in sentencing disparity. And what we're doing is just changing, what we're doing is carving out exceptions to every single rule. And I think that we go too far with that, and we might as well just trash it and start over with independent or indeterminate sentences if we want to do that.
Just so we're clear, counsel, you want us to affirm what the Court of Appeals did.
Oh, absolutely. I'm sorry. Yes, I want you to affirm the Court of Appeals in its entirety. And if there's any thing to be changed, I suppose I'd ask that we adopt Justice Johnson's suggestion that correction of an illegal sentence is not modification, and you correct that part of the sentence that is illegal.
All right, do we have any more questions? Thank you, counsel.
Thank you.
May it please the court. I sat over here, maybe confusing myself even more, but I just wanted to be clear on the remedies that I'm asking for. First, I'm asking that the district court is affirmed with the 279 months. Not an easy way to get there, but my briefing, I think, explains how you can get there. Second remedy, my alternative remedy, is I'm coming up with a number that the district court, or that the Court of Appeals 221 could actually be 255. And the way I'm getting there is, if we look at the original sentencing, I have the transcript from January 2002. The district court, or Judge Andrews did 253 for count 1. On count 2, aggravated robbery, I will reduce the sentence from 59 to 35 months and make that consecutive to count 1. And 35 months on count 3 and make that concurrent to counts 2 and 1. So if this court finds that Judge Wilson should have only found count 1, the murder, illegal, and count 3, the conspiracy, illegal, I think the district court actually did the 35-month robbery consecutive. So I think we can do 186 consecutive to 30, or 35 consecutive to that, and 34 consecutive to that to get to 255. Which I don't know that that's ever been brought up until now.
That's changing the original concurrent conspiracy to a consecutive.
Yes, which I'm arguing we can do now because that sentence was found illegal, and under 4720, the judge can take into consideration consecutive versus concurrent. So I'm tweaking it even more to throw in 255.
And so when you change the sentence from concurrent to consecutive, it's not a modification?
If it's been found illegal, I don't think so.
Okay.
So those would be my requests for this court, and thank you for your time.
Do we have any more questions? Thank you, counsel. Thank you both for the arguments this morning and this afternoon. The court will take this matter under advisement.